I'm Monica Milton, Counsel for Public Defense and Special Projects here at NACDL, and I'm pleased to welcome you to this week's Engage and Exchange: Why Supreme Court Reform Matters. We are joined by the Brennan Center, so we're really excited to get to this program. Just some brief housekeeping. We ask that if you have questions for the panelists, you put them in the Q&A function located at the bottom of your screen. If you have links or anything you want to say in the chat, you can feel free to talk amongst yourselves in the chat. We'll be monitoring both, but we hope that you'll put your questions for the actual panel in the Q&A. This program is being recorded, and you will receive the recording along with any resources that we share today in an email in a few days after some light editing. With that said, I'm going to pass it over to NACDL's Executive Director, Lisa Wang, to do some brief introductory remarks.
Thank you, Monica. NACDL prides itself on bringing you the trending topics of the moment, and this is a trending topic. I had the opportunity to speak with the folks at the Brennan Center for Justice a couple months ago, and they started telling me about their ideas and what they're going to discuss with you, and I thought to myself, I need to bring this to our members. And so here they are, and I'm just so excited that the Brennan Center for Justice, who has some of the smartest individuals I know who are working in this space, thinking of how to create a fair world for us and for our clients. Well, here they are, and I'm just thrilled that you're here. So thank you very much, and I'm not going to waste a moment getting on with the program.
Thank you so much, Executive Director Wayne. Hello, everyone. My name is Eliazar Chacha. I'm a counsel here at the Brennan Center for Justice. I would like to especially thank Executive Director Wayne for inviting us to speak to you all today. As background, in December 2024, the Brennan Center for Justice launched the Kohlberg Center on the U.S. Supreme Court, which is an initiative designed to research and advocate for reforms aimed at strengthening confidence in the federal judiciary. So far, we've hosted off-the-record dinners and met with retired judges, legal scholars, academics, and other experts across the ideological spectrum to unearth where there may be areas of consensus on issues that include a stronger code of ethics for Supreme Court justices, 18-year term limits, and other timely reforms. As part of this work, we had the honor of meeting with NACDL leadership last November, as Executive Director Wayne mentioned, where we had a very productive conversation about these proposals. Thank you again for inviting us back to speak to you all. As many of you know all too well, the Supreme Court of the United States plays an important role in American life. Its decisions shape the contours of our rights, define the limits of governmental power, influence the lived experience of communities nationwide, and directly impacts the freedoms of the people you all defend in the court of law. As public debate about the court has intensified, we hope today's conversation highlights how questions of judicial reform are inseparable from questions of representation, fairness, and equal justice under law. And now it's my pleasure to introduce my colleagues and provide you with a brief run of show. Starting us off today is the Kohlberg Center's Managing Director, Stephen Spaulding, who will provide us with a brief overview of the Kohlberg Center's work, along with pertinent polling and data to help contextualize Supreme Court reform in this moment in our nation's history. We will then turn to Brennan Center Senior Fellow Miriam Rosenbaum, who will focus on Supreme Court ethics reform and why it is needed today. We will end our conversation with a presentation from retired federal district judge and current Harvard Law School senior lecturer, Nancy Gertner. Judge Gertner, who among other courses teaches criminal law and procedure and mass incarceration and sentencing law at Harvard Law School. She will discuss the importance of 18-year term limits for Supreme Court justices, why judges like her support the reform, and why criminal defense lawyers like ourselves should too. In the interest of time, I will post all of their bios in the chat for you all to access. We will make sure to leave ample time at the end to answer any of your questions, so please feel free to put them in the Q&A box. And I will be monitoring that throughout the discussion today, and we will make sure to highlight all those questions towards the end. Thanks again. I'll now turn it to Steve to start us off.
Thank you, Eliazar. Thank you, Lisa, Monica. Thank you to NACDL for having us today, and Miriam and Judge Gertner, of course, for joining this important conversation. Eliazar teed up to what the Kohlberg Center at the Brennan Center is working on, and I'll just back up and provide a little context too on the Brennan Center. The Brennan Center is a nonpartisan think tank, advocacy organization, communications hub affiliated with NYU Law School that is looking at strengthening and defending American democracy. And as part of that, the Kohlberg Center is our team that is focused on studying the Supreme Court. We are bringing together scholars. We're holding public and private symposia. We're publishing policy reports and research and working to really study reforms to the court that will strengthen trust and confidence in the judicial branch. Some of those solutions that we're really prioritizing and lifting up include ethics, include term limits for the justices, and other new ideas that would strengthen the judiciary. Towards that end, we'll share some of our resources. One is the Benchmark, which is a resource hub where we're hosting both internal and external authors to look at the court, study it, analyze it. We have a new newsletter that we've launched called Major Questions. We recently were joined by Jesse Wegman, a former member of the New York Times editorial board, who's going to be sharing his analysis and thoughts on the Supreme Court. So these are all resources that you should feel free to explore, and we'll make sure that this is shared in our follow-up. But this work is really coming at a time where public confidence in the court, as I mentioned, is hovering at record lows. I think it was in 2022, excuse me, it was just earlier this month where NBC News released a poll that found only 22% of Americans have a great deal of confidence in the Supreme Court. It's happening at a time where trust in institutions writ large have been dipping at record lows. For example, there was a Gallup poll, I think last summer, that found that approval was below 40% for the first time in Gallup's polling. The other thing I wanted to raise is there's also a significant partisan gap that we're seeing, and that's relatively new. There was a poll out of Pew Research in the fall, which found that only 26% of Democrats viewed the court favorably compared to 71% of Republicans. And from any perspective, that's a challenge when you have that kind of a divide between people by party when it comes to the court. So we know there is a confidence and a trust problem, and there are, a variety of hypotheses I think that we can lay out. One is that people have seen how the court has set the conditions for much of what we're seeing in our democracy. In some respects, Americans have fewer rights than they did before. You can look at a through line from Citizens United and the avalanche of money that it unleashed, Shelby County's gutting of the Voting Rights Act, Rucho's greenlighting of partisan gerrymandering, and of course, Dobbs taking away federal constitutional right to abortion. And at the same time, we can't lose sight of a cavalier approach that we have seen from some regarding ethics and the cascade of scandals that have been reported. Then there's the way that the court has been making its decisions, especially last year and this year, where it is using the emergency docket or the shadow docket in unprecedented ways to make decisions that have a real world impact, often without explaining itself. The results, scientific research funding frozen, the Department of Education dismantled, Americans being swept up in immigration raids based on what they look like or the language they speak, civil servants fired en masse. All of this is leading to deteriorating trust in the institution and a need for us to get ourselves back on track. And so with that, I'll turn it back over to Eliazar to proceed with our conversation about what some of these reforms are. Thanks, Eliazar.
Thanks, Steve, so much for setting the table for us. I will now pass it over to our senior fellow, Miriam Rosenbaum, to discuss ethics reform, which is one of the two reforms we will talk about today. Then we'll pass it to Judge Gertner to end us with term limits. Thanks, Steve.
Thank you, Eliazar, and thank you again, Monica and Lisa and Shuli, for having us today. It's such a pleasure to get to talk to all of you. I want to talk a little bit about ethics reform for Supreme Court justices. Before I talk about ethics for Supreme Court justices and address what is missing there, we first have to know what type of ethics rules apply to all other federal judges. So to backtrack, the Judicial Conference of the United States adopted the Code of Conduct for U.S. judges for lower federal courts in 1973. All judges, except for SCOTUS judges, are bound by this code, and the rules in this code are enforceable through complaints and investigations. The code for judges outlines all sorts of rules and regulations, such as rules for recusal. And the code says about recusal that a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned because of a host of factors: personal bias, past representation of a party, financial interest, or role of a spouse. But I want to emphasize that word shall. It also talks about political activity restrictions. The code restricts judges from engaging in political activities, such as holding office or endorsing candidates. And it also addresses other extrajudicial activities about when and how a judge can speak, write, teach, publish. Going back to the Supreme Court justices who are not bound by this code, in 2011, there was a lot of public concern about the lack of code for Supreme Court justices, primarily stemming from pushback around the Affordable Care Act. Both Justices Kagan and Justices Kagan and Thomas had a connection to the ACA. So Kagan had worked for Obama when the policy was being crafted, and Justice Thomas's wife was part of a group that vigorously opposed the ACA. And a lot of the public thought that they should recuse themselves, and this didn't happen. In response to this public backlash, at the end of 2011, Chief Justice Roberts addressed the lack of ethics code for SCOTUS in his year-end report. And he said, we're rejecting a call for greater reform. And he wrote, all members of the court do in fact consult the code of conduct in assessing their ethical obligations. In this way, the code plays the same role for the justices as it does for the other federal judges, essentially saying, trust us, we don't need a code of conduct. We're following what everyone else does, even though we're not bound by it. So this acknowledgement obviously was still insufficient, and public concern continued to grow over the next decade amidst a number of scandals with the justices, many of which I'm sure you've read about. Alito and Thomas received gifts and travel from very wealthy individuals who were involved in cases that went before the court. There was also a lot of concern when Justice Thomas didn't recuse himself from the January 6 cases, even though his wife was involved in legal efforts to keep Trump in office. And in 2023, SCOTUS responded again to public outcry by implementing its own code of conduct, which very much mirrors the general judicial code of conduct, but is severely deficient and different in a few ways. The first thing is that it is not enforceable. There are no mechanisms and no oversight body to make sure that the justices are following this code or to report or any concerns when a party might think that a justice is not following it. The whole framing of the code of conduct that SCOTUS adopted in 2023 is apparent from the introduction to the code, where the justices write that the goal of this is to correct any misunderstanding about SCOTUS's behavior. The code of conduct does not start with an introduction about how the goal is to address underlying behavior, but just to address misunderstandings that the public have. So it was the public's issue, not the justice's issue. So as I mentioned, the code of conduct adopted in 2023 does not have an enforcement mechanism. With regard to recusal, I mentioned earlier on that the standard for other federal judges is judges shall recuse themselves. The justices should recuse themselves, meaning that they should consider it. They don't have to. The code of conduct states that SCOTUS justices are presumed impartial and have an obligation to sit unless disqualified, which isn't true for other judges. There's also no requirement for a written explanation for when a justice chooses to recuse themselves or not. And there's also a phrase that the rule of necessity may override the rule of disqualification, which means that a justice can self-determine that the need for 9 justices outweighs ethical questions that might be at issue. So while this code of ethics implemented in 2023 is a great step, it is not sufficient. I also want to make clear that I don't think, and the Brennan Center in general doesn't think that, our justices are all corrupt and terrible and that their ethics need to be fixed. The biggest issue not having a code of conduct is perception. So even if the justices really are self-policing and recusing themselves when they should, if the public doesn't have confidence in this code or confidence that the justices are doing the right thing, that hurts the court just as much as like what is actually happening. So one solution to this is a bill that's been introduced called the Supreme Court Ethics, Recusal, and Transparency Act. And the main features of this bill that we support are the requirement for an enforcement mechanism so that there is a way similar to other federal judges for an outside body to monitor when an issue comes up and make a written decision with the outcome. The bill that An element of the bill that we also support is a written requirement to explain a decision of whether or not to recuse oneself as a justice, and also stricter gift policies with more regular disclosures. So I look forward to answering more questions that may come up, but this is something that we would love to partner with, and later on in the discussion talk about how we might work together on, achieving some of these objectives if you all think that they're important.
Now it's my turn.
Yes,
Yeah.
thank you so much, Miriam. I will pass it now to Judge Gertner to talk about term limits. Thank you so much, Judge Gertner, for joining us. I really appreciate it.
Well, so I can't say that this was a topic that I had focused on when I was a judge, focused on what the Supreme Court is doing in terms of term limits. I was on the White House Commission on the Supreme Court, and the commission's charge was to look at all aspects of Supreme Court reform. It was not our job to make recommendations. It was really just to plumb the depths of all the arguments. I came away firmly convinced that the Supreme Court must have term limits, and firmly convinced that there's not a constitutional issue. And I do so for numbers of reasons. One is that we have an extraordinarily powerful Supreme Court. And the content of the Supreme Court, the makeup of the Supreme Court, shouldn't depend on the happenstance of who dies when. Every single other high court in the Western world has term limits and or a mandatory retirement age. In fact, every single 31 states in the District of Columbia also have some form of mandatory retirement, and almost all state courts establish a term. So other Western democracies, other state courts, it is simply the historical accident that we didn't. One scholar who remarkable testimony, who testified before the Commission on the Supreme Court, said, "Were we writing the United States Constitution anew, there is no way we would adopt the particular institutional structure that we have for judicial tenure. No other country has true lifetime tenure for its justices, and for good reason." The court is always out of sync with the popular will, because the court is in place for whatever the tenure may be. It doesn't match the tenure of the appointing president. But this Supreme Court is dramatically out of sync. 3 justices, relatively young justices in the court for the foreseeable future. So the recent versions of reform call for justices to take senior status after 18 years of active service. That means they remain a judge. They have the same judicial officers. They would have the same clerk. But after 18 years, they would take on new duties, such as deciding original jurisdiction cases, hearing cases on circuit, or even filling in for recused justices. This essentially mirrors the system we already have in place. Once a judge reaches a certain age and a certain year of service, this is federal judges, lower federal judges, you can take senior status, which means, again, you keep your salary because the Constitution says that a judge remains a judge during good behavior. So it's critical that you keep your salary and status and the other, accoutrements of your office. So with a senior judge, you take senior status and take whatever duties you wish to take. The same thing would happen for the Supreme Court. At 18 years, they would retire from active service, receiving the same salary, and ride circuit. We already have seen this. Justice Breyer, Souter, and Sandra Day O'Connor periodically sat on appeals courts when they retired from the Supreme Court. I don't believe there would be any constitutional issue involved because the status of the justice would remain the same, except their duties will have been reassigned. The senior justice system was upheld by the Supreme Court in 1934, and the Supreme Court expressly held then that judges who take senior status continue in office for the purpose of the Constitution. So there's really no constitutional bar. There's no rational bar. This would make sense if we were starting afresh. And it certainly makes sense in terms of the kinds of issues that Miriam Rosenbaum talked about and Steve Spaulding talked about, which is a court that needs to be reformed. And the reform is ethics reform on the one hand, and term limit reform. 18 years is a long time. I served for 14, and it was a very long time. And let me say also, this would enable, one proposal would enable a rational process of selection, and not just who happens to die when. There would be, the 2 slots on the court would open up during each 4-year presidential term. So every president would have an opportunity to appoint 2 justices, and the court would be refreshed over time in a way that is rational, in a way that would enhance its legitimacy. So this is, I think, a reform whose time has come.
Thank you so much, Judge Gertner. There's a question that's posted in the chat, but before I answer that question, I'm wondering if each of you can talk about why these reforms should matter to NACDL members, who many of them who represent people in court, who on the criminal defense side. I know for me, one of the cases was Trump v. United States, when we learned that, where I thought that every person was equal under law, but I guess that's not the case anymore, right? Except for one. And so I'm wondering if you can speak to why ethics reform and why term limits should matter to someone who's part of this membership.
I mean, I can jump in because I think that what is motivating this work on my end is the need for confidence in the courts to stay strong. I think that anyone who is at trial, who appears before any judge, needs to have confidence that the judge will be fair and ethical, and having a codified standard of ethics where justices are held to the highest standards helps instill confidence in our judicial system, and helps people who appear before the court know that they're being treated in the same way and with the same standards that the justices themselves are bound to.
I think there's also a democracy reason. Whatever one thinks of the politics of this, certainly there are 3 appointments to the Supreme Court now as to whom there was controversy. You may agree with it, you may not, right? Merrick Garland's nomination was held up by Mitch McConnell for a year because because it was too close to an election. But then Justice Barrett was selected within 3 months of an election. So all of a sudden there were now 2 appointments. Justice Kavanaugh, there were issues surrounding his selection as well. And so arguably, some who said to us, one scholar who before the White House Commission said, you know, to say that this is a process to have any given president pack the courts is not true. This is essentially unpacking the courts and providing a rational system of appointment, a rational system to refresh the courts, comparable to the rational system we have in largely every other court in the Western world and every other court in the country. So this, as I said, is a change whose time has come. And criminal defense lawyers, civil rights lawyers should care about this, because what happens is that opinions get reified, get solidified, get unchanged when the court doesn't change. And we should all be concerned about that.
Completely agree. Thank you so much. I'm going to turn it to a chat now. So Christopher Gregory asked, Judge Gertner, does your proposal for term limits include staggering to avoid the influence of a single presidential administration?
Yes, the latest proposal has 2 slots on the court would open up each four-year presidential term. So it would be, you would stagger it, and there are different proposals for how we would begin to implement it. But the ultimate point would be to have 2 slots opening up in every presidential term. Which really, as I said, when you think about how extraordinarily powerful the Supreme Court is, the last word on everything, how particularly at a time when Congress is, as one person described it in a presentation the other day, sclerotic, which I thought was a great word. If Congress is sclerotic, the executive is quite aggressive. The court then, and this large, for the most part, the 6-3 majority has absolutely enormous power, more power than any given court should have in a democracy.
I'll just jump in real quick too to co-sign everything that's been said. And you may have seen quite a bit of chatter in the press about the potential for a retirement this term or next term, which would then set up a situation where you'd have one president, this president, nominating a 4th or perhaps a 5th or perhaps a 6th justice. So this reform specifically also addresses, because as Judge Gertner said, the 2 appointments per term, the current proposal out there, you would address this issue of strategic retirements, where one person can essentially control their legacy for another 30 or 40 years. It should not be that one president, by the luck of the draw or by strategy, has such an outsized impact on the court for generations. And this reform would directly address that. In a way, as Judge Gertner also said, that 49 states out of 50 take on in some way, whether it is mandatory retirement age, retention elections, and every other major constitutional democracy in the world. The court really is an outlier in this respect. And I think if there is this vacancy, it will be a point of contention and something that will energize, I think, efforts around this. Frankly, no matter who the president is that is making these appointments, it would have this sort of an outsized influence on the makeup of the court.
And to that point, thanks, Steve, for that. And to that point, many of us learned in law school that judges have their jobs for life. Good behavior means for life. And I think, Judge Gertner, you discussed this briefly when you said, look, they will still retain their office for life, right? Just after 18 years, they will retire. They will become senior justices, right?
Right.
This new
Right.
proposal for senior justices. Can you talk more about that and why this isn't removing them from office? And especially there's this big difference between voluntarily taking on senior status versus after 18 years being moving on to that. And so can you assuage some of our worries about, like, no, they will still retain their office for life. This is not in contradiction to what you learn in law school about judges having their jobs for life.
The Constitution talks about for good behavior. And as I was saying, in 1934, the court, then Supreme Court, had to deal with the constitutionality of the senior status provision for lower federal courts judges. And the question was whether or not a district court or circuit judge who's taken senior status continues in the office for the purpose of Article 3, Section 1. The court was unanimous that essentially a retired judge's, a senior judge's judicial acts are part of the office of the judge. So 1934, if it was lawful for lower federal courts to have senior judges to take senior status and still be consistent with the Constitution, then it surely is lawful for the Supreme Court to do so. Now, your point is well taken. The difference between lower court judges taking senior status and this proposal for the Supreme Court is that it would be mandatory. After 18 years, they would have to choose to either A, retire, or B, take senior status. When I reached that point, when I was a judge, I didn't have to leave. I chose to leave because I love to speak. And the job didn't enable me to speak as much as I wanted to speak. And that was my choice. I don't think that the choice issue changes the status question. The status remains. You have to go, just as Congress under the Constitution has the right to determine the jurisdiction of the court, the kinds of cases that it must take or may take. This would really be no different. As long as a judge retains both his salary and his office. And then, it's also interesting. I think it would actually enhance, it is not just for the Supreme Court, it would enhance the decision-making across the country. Justice Breyer periodically sits on the court that he left to become a Supreme Court justice, which was the First Circuit, and brings a wealth of knowledge and information and independence that other judges may not have. So I think it's a good thing. Part of the proposal is also that the judges could then ride circuit. Wouldn't that be remarkable? Go see the country, judge or justice. So it is a democracy refreshing proposal, as opposed to a democracy rigidifying Supreme Court, which is what we have.
I love that. Democracy refreshing. I love that. Especially in this moment, we need a democracy refreshing reform. Executive Director Lisa Wayne asked, how would we implement it? What are the mechanisms of getting term limits through Congress?
There would be legislation.
Yep.
If Lisa, hi, is asking the question of, how we get it through politically, I haven't the foggiest idea. I imagine that in these days it would be difficult. But it certainly is something we have to try. It's something that would be difficult because the polarization, of the Congress. Then we try in Congress after Congress. Again, this is the quote that I gave to everyone about how we never would have done this if we are setting up a constitution today is telling. We have created a system of a supremely powerful court that is frozen in time, but for the happenstance of who dies when.
Completely agree. Steve, I see that you unmuted. And if you can also bring in and talk about the polling data you saw about,
Of course.
this is really popular amongst Democrats, Republicans, and independents.
Of course. So I should mention that. So on the legislative front, there is a bill. There's a few bills that have been pending in Congress. One that has the most number of co-sponsors is called the Term Act. It's HR 3544. It's been introduced by Representative Hank Johnson of Georgia. The first named co-sponsor is Ranking Member Raskin of the House Judiciary Committee. There's now 59 members on that bill. 2 just joined actually during the pro forma last week. So there are members of Congress that are interested in this and that are organizing around a vehicle in the House. There's another bill led by Representative Ro Khanna that has, I think, 8 or 9 co-sponsors. The difference between the 2 bills, there's a few differences. One would only apply prospectively. One would apply to the most senior justice and go back every 2 years. There's a third proposal, a constitutional amendment that's been introduced by a Republican from Michigan, Representative Tom Barrett, that would establish 20-year term limits, which would make the math a little more complicated in terms of having 2 new justices per presidential term. But that's another proposal that's on the table. And something that we are preparing for is the moment where pro-democracy champions are able to advance legislation. It often is the case that following dissatisfaction or scandal comes reform. I think we saw that most acutely after Watergate, where Congress passed a whole host of reforms to our ethics laws, to our laws that govern the influence of money in the political system. And we need to be prepared, and we are preparing for a similar moment where things can be rebuilt, reimagined in a way that align with current values. I'm also reminded of there was a convening of a number of constitutional scholars and others at the National Constitution Center in Philadelphia, where sort of progressive, self-identified progressives and self-identified conservatives met separately to discuss their reforms. And one reform that they both came up with independently and separately was the idea of Supreme Court term limits. On the polling, to the extent that also helps with building the public case and persuading members of Congress, it is enormously popular with the public consistently and across ideologies. Fox News, for example, did a poll in 2024 that found support at 78%. There have been subsequent polls that have also found strong support across Democrats, Independents, and Republicans. And I'm putting in the chat a resource that we have pulled together at the Brennan Center, at the Kohlberg Center, that pulls together reputable polls over the past 5 years that looks at not only specific reforms like ethics and term limits, but also Supreme Court approval generally, Supreme Court favorability, trust, confidence in the court. You can see on that resource this database of all of the polls and see the top lines. Read the cross sections if, like me, you're really interested in polling and seeing that. But check that out. On the whole, this is something that is popular. It's also the case that sometimes when things are popular outside of the country, they're not always popular inside the Beltway. But we're doing what we can to build the support to get it across the finish line at the earliest opportunity.
Thank you so much, Steve. Miriam, I want to bring you in if you have anything to add. I can also go to the next question, but
I agree with everything that Steve and Judge Gertner said. So
great. If term limits and a binding ethics code were implemented today, what measurable changes should we expect in 5 to 10 years?
Well, we wouldn't, this is for Miriam. I mean, hopefully we wouldn't have the kinds of stories that we have seen with respect to Judge Thomas on the one hand and Judge Alito on the other. And we wouldn't have that kind of, hopefully wouldn't have that kind of conduct. I want to underscore what Miriam said, though. The judges that I served with and the judges I met all across the country, the lower court judges, were unbelievably scrupulous about following the code of ethics. It was sort of something which defined the difference between being a judge and an ordinary citizen. And the rules with respect to, for example, how much money you could make from outside income, it was very limited. Even to get teaching income, you could only earn a very small amount of money from outside teaching. And the reason was that the rules were intended to make certain that you focused on your job as a judge and were not distracted and were not influenced by anything else. You were going to focus on your job as a judge rather than do a speaking tour where you would get lots of other money. There were proposals for which Miriam probably would know about, to allow judges to take honorarium. And they were resoundingly rejected by Congress because of the fear of outside influence. That judges who were getting big bucks for their speeches could be influenced by the source, by the funder. So the notion that judges were doing an end run around this was particularly the accusations against Justice Thomas, were doing an end run around it, were extraordinarily troubling, I think, to every judge in the country. The notion of private planes rather than, I regularly commuted to Yale in the cattle car, it sometimes felt like, or taking planes where you were essentially scrunched in the back because you wanted to make sure lest anyone believed that you were getting more money for it than you should. And so I think ethics code, an enforceable ethics code, there are questions about how one can do that, who would do the enforcing, but I think would make an enormous difference to the legitimacy of the court. And it makes no sense that the court with the most power should be regulated the least. So I endorse what Miriam is saying.
And to speak to your piece, Judge Gertner, on term limits, I think one change we might see if term limits were implemented in the next 5 to 10 years is the temperature dialing down around confirmations when we have vacancies. Because if there is an understanding that every 2 years there will be a vacancy, I think it would make it less contentious each time something opens up every, rare occasion. And I also think that we might get different types of justices nominated if there's an understanding that they're only there for 18 years, meaning that there could be an incentive to put younger and less experienced justices on the court to keep them on as long as possible if there were no term limits. And I think with the knowledge that there are term limits, as we approach vacancies, age will not be a factor. And so we may get more experienced justices put into those slots that open.
And as you said, it will change the nomination process. The nomination process is woefully broken in terms of who gets selected and how they're selected. And that's because of the incredible weight of each individual selection forever for the term of their life, by the happenstance of the president selecting them. So the costs are so high, and so I think it makes a difference to the selection process, as Miriam said.
And to Miriam's point, we could hopefully also add a justice with a criminal defense background. Who knows, right? More different perspectives. But that's a great segue to our next question to you, Judge Gertner. As a retired federal judge, can you speak to how term limits might change the appointment process and reduce the political stakes of nominations? And if you can talk more about your experience going through that process and how that it could have been impacted, that would be great.
Well, I think it will for the Supreme Court. I mean, I think we've talked about that before, which is if you know you're going to get a regular appointment, each appointment has less valence, it's less politically fraught, because you'll get another two in the term of the next president. When I got on the District of Massachusetts, I was the first and only criminal defense lawyer on the court for the 14 years that I served, for the 17 years that I served, sorry. This has changed. I mean, the selection process when I got on the bench under Clinton, was largely you would pick people who seemed incredibly safe to get on the court. And that was largely prosecutors. The bench is still overwhelmingly made up of people with a prosecutorial background and not with a defense background. That has changed, particularly with Biden's appointments, and it makes a difference. I was telling my class the other day that I remember cross-examining police officers as a criminal defense lawyer. I didn't believe that every police officer was lying, but I certainly had encountered some who I was convinced were. When I got on the bench, I knew that was possible, that officers might lie. One of my colleagues at lunch said to me that he's never had any experience with an officer lying and not believe that it happens except in the teeny-weeny number of cases. And it occurred to me that if you start not even being able to envision the problem, you will not see it when it happens. And I certainly could envision it. It didn't mean that I, ruled against police officers in every case. It was extremely rare, but it meant that I was attentive to the signs in a way that some other judge, might be. It also mattered that although I was a criminal defense lawyer and a member of the of NACDL, I did some white collar defense, but I did a whole lot of cases. I had a sliding scale, and one end of it was free. So I did a fair amount of work for people who had no means, or maybe they had means, but they weren't telling me. And that experience also affects judging. You understand when you have cut this lawyer's fees, what that's going to mean for the next case. You understand when you refuse to allow funds for a psychiatrist or a forensic expert, that the disproportion between the prosecutor and the defense resources is exacerbated. So if the proposals open up different people to the court, I mean, Miriam's point that that you'll have another round in the next presidential term might mean that, again, any given selection is not as fraught as when you believe you're selecting a justice for the next 900 years. Yeah, I mean, but I made it because of Ted Kennedy, who was at the end of his career and decided to make a project of me. In 1994, that was not generally the case.
And how lucky we are for that decision. Thank you so much for your years of service, and thank you so much, Judge Gertner. So many people who are attending the webinar right now are in offices throughout the country. And so maybe they're wondering, how can I effectively advocate for these reforms from my office space, from a place where I don't want to appear too partisan, but I truly believe in these reforms? So if that's the case, how can I be part of the solution here? So I want to open it up to you, Judge Gertner, or Miriam, or Stephen, talk about what are some of the ways that the NACDL can become a part of this movement, but also individual lawyers themselves who want to be a part of this and want to speak out. I know, for instance, Steve and I came from the Capitol Hill, where we loved hearing from constituents who told us, "Hey, this bill is here. The member should consider supporting it." I know some bar associations, for instance, also do fly-ins on the Hill, where they come to office and talk to us about the importance of these different bills, which help put those on the map. But what are some other ways that folks can get involved? Steve?
Sure, I'm happy to jump in. I think I like to think of this as there's many ways to get engaged. Talking to your colleagues and talking to fellow members of your bar associations and other like-minded affinity groups that you were involved in, and just share these ideas, and share, even to the extent you're able to. I mean, there are places to engage, whether it is lending support through a resolution or a letter to the editor or even a tweet that tags an elected official. They see that. Eliazar mentioned both of us have worked on the Hill, and when someone's name is mentioned in the paper or online, it elicits a response, and people pay attention to that. That's some of the nitty gritty. Staying engaged and to the extent that you have speaking opportunities. We would be thrilled to share this presentation or other presentations throughout the country. We're going to be speaking to the extent that you may be mentoring law students or junior lawyers. Sharing these resources with them and socializing these ideas is also welcome.
Couldn't agree more. So we have two more questions in the chat. First, one is a statement. This is to you, Judge Gertner. And the experience of having been a criminal defense lawyer do you think, Judge Gertner, give you a different sense of when things are actually harmful?
Oh, it absolutely did. My first partner was Harvey Silverglade, and I remember he said to me that 1 minute in imprisonment is too much. And wow. And I remember, I mean, when you had to visit people who were in prison, state prison, federal prison, and then when I became a judge, there in baby judge school, and yes, it's called that, you'd go visit a prison, and it was so different than the conditions I had seen when I was a lawyer. And I knew the difference. We were, it was spanking clean. We were speaking to prisoners that had been handpicked by the institution. And it was helpful to know what I knew and see what I had seen. There was a proposal once that every every federal judge and state judge should go to the worst prisons, not the best, and see what it's like. I also, I mean, as I said, I teach other judges, and I hear them say things about what the services that will be provided in prisons. And both from my academic work and from my practical experience, I know that some of that is not the case. You want to believe that there will be fabulous medical care, or that there will be, reasonable therapy or drug treatment. But in fact, in most low-resourced prisons, that's just not true.
Completely agree. Javal Scott asks, as attorneys, we understand the importance of this change. What are the best ways to message the need for this change to the average community member?
So I have found that the most effective one-line way to describe why we need these reforms is that no one person should have so much power for so long. A Supreme Court justice with no enforceable code of conduct and with no term limits has more power than a president does, has more power than anyone else in the country, and um, no one person should have that much power.
Yep. No, and especially now. The Constitution was premised on a separation of powers, a balance between three branches. We have a situation in which one branch, the executive branch, is enormously active. The Congress is not acting as a check, and the only check on this president are the courts and the lower federal courts. I believe the latest tally is 650 cases were brought challenging the Trump administration's actions. And I also believe that the numbers of successful challenges at the lower court, to a degree in the Court of Appeals, is about 60%. It doesn't matter who the judge was, whether they were appointed by a Republican or a Democrat. The Supreme Court has been different, no question about it, but that may be changing. And the Supreme Court has been exercising its power in a contested area, in the shadow docket cases, where they are ruling in ways that are frankly incomprehensible to the judges, ununderstandable and incomprehensible. I think even the public, everyone in the public should realize there's a need for change.
Thank you so much. So we have a couple minutes left. I'm wondering if we can go down the line and say if you can provide one takeaway that you want every member who's listening here to take away from this conversation. If we can start with you, Steve, then we'll go to Miriam and then Judge Gertner.
Yeah, I'll thank you for taking the time today, and for staying with us. I mean, I think my one takeaway is, like, please stay engaged and please talk to your associates, to your colleagues about this and about ways to learn more. And as opportunities arise, where we can put points on the board and advance solutions and make a difference in strengthening confidence and trust in the court, like, take them as we can. And to the extent you're able to bring more people in, we would most welcome that.
I'm going to do two short takeaways because I can't
No
decide which one is
problem.
more important. The first I would say is that even though this seems like big change that can never happen, I urge people to think about the history of the Supreme Court and how Congress has legislated in ways that have affected the court, the size of the court, the jurisdiction of the court throughout history, and like this is possible. The second thing, to go back to the earlier question about how to talk to people about why this is important. I think it's important. I think it's crucial to explain that a lot of the changes we want to see in the country can only happen with the Supreme Court's approval. So even yesterday, on Monday, I was at a conference with Judge Gertner on the future of the DOJ, and every proposal on how to prevent abusive prosecution came back to, like, what will the Supreme Court do when a change lives through its life cycle? So any conversation we have about current events or democracy in general does implicate having a Supreme Court that's functioning well and has public confidence. So that's what I would love to impart.
I completely agree with that. Miriam and I were at the same conference. But I also think that if you think about a rational system, this would not have been it. If you think about a fair system, a system that is worth the enormous power that it has, this would not be it. And so if you start from that point, it doesn't matter whether you're a Democrat or a Republican, this is not a functional system for a democracy. 9 people have an extraordinary amount of power for the foreseeable future, and a 6-person majority has essentially that power in numbers of areas and and again into the future. It's not a rational system. It's not a fair system. It's not the way a democracy should operate.
I couldn't have said it better myself. Thank you so much. On behalf of the Brennan Center for Justice's Kohlberg Center on the U.S. Supreme Court, I want to extend my sincere gratitude to Executive Director Wayne, Monica Milton, Julie Carroll, and the entire NACDL board for convening this important conversation, and to all of you for your time, your engagement, and your thoughtful questions. I also want to thank our exceptional speakers, Stephen Spaulding, Miriam Rosenbaum, and Judge Nancy Gertner for sharing their expertise and their insight. At the Brennan Center's Kohlberg Center on the U.S. Supreme Court, we remain committed to continuing these conversations, bringing together diverse voices, grounding proposals in rigorous research, and working towards solutions that reinforce confidence in the rule of law. Finally, I want to leave you with this. The future of the court is not just a question for scholars or judges. It is a question for all of us, particularly those of you who are on the front lines of defending rights and advancing justice every day. Your perspectives, your advocacy, and your engagement are essential to shaping what comes next. Thank you again for being part of today's discussion. We look forward to staying in touch and continuing this important work together. Thank you. I'll pass it to Monica and Executive Director Wayne. Thank you so much, you all.
Thank you so much. This was an excellent presentation. I don't know if Lisa, you wanted to say something before I close out.
No, I just appreciate everybody giving us their time, and I know that there will be more discussions about this.